you if your cease and desist notice got ignored and the other side kept selling anyway, now what to do? So in this video, I am going to show you exactly how to draft the document that comes next, which is an interim application. And under this, we seek an urgent injunction from the court under Order 39, Rule 1 and 2 to be read with Section 151 of the CPC. And I'm not just going to hand you a template. Like if you are a first year law student, so I am going to start from zero about what an injunction even is. And if you are a junior advocate already filing these, so stay through the part B because this class is divided into two parts. And part A is foundations, where we will be explaining about terms like Order 39 or Ad-interim, which feels unfamiliar. And part B would be a practical drafting part where we will build a complete real application paragraph by paragraph by continuing the Sundrop Beverages story from our Cease and Desist Notice session. So, at whichever stage you are at, stay with me through part A, even if you feels that it's basic, and because the drafting in part B will make far more sense once the foundation is solid. So let's start at the very beginning. Before we touch a single paragraph of drafting, I want every one of you, regardless of your year or experience, to be completely solid on what an injunction actually is and where the power to grant one comes from and why the timing matters so much in these applications. Okay, so these are the 8 words. If you are new to litigation, these words alone will unlock most of what confuses student about the interim application. If we talk about a suit, okay, so a suit is the main legal proceeding. For example, here it is commercial suit in this class, which we will be going to discuss. And an application, if we talk about, or IA, is a specific request which is made within that suit. Okay, so the application rides inside the suit. And if we talk about the plaintiff or applicant, it is the party who filed the suit and who is now seeking an urgent relief. Same goes for the defendant, where the applications are directed against. In affidavit, we talk about a statement of facts and which is used to support the application. Okay, and this is basically given at the end of the document that everything stated above is true. Okay, and last two parts that confuse almost every first year student, that what does ex parte means. So ex parte means an order passed after hearing only one side. Okay, and here uh, we don't give notice to the other party. Okay, and to vacate means an injunction uh, means to cancel or set aside one that was already granted. So keep these words in your mind because we will be using every single one of these words for the rest of today's class. Now, coming to this part, that what exactly is an injunction? So, in plain terms, if we talk about an injunction, so we call it as a judicial order that either stops a party from doing something or forces a party to do something in order to preserve the subject matter of the dispute until the court can finally decide it. Okay, so there are two basic types, that is a prohibitory or negative injunction, which restrains a party from doing something. Okay, Like this is what we were seeking in Sunoora Foods, that stop selling the goods under the Sunoora mark. Okay. And a mandatory or positive injunction compels a party to actively do something. For instance, directing a defendant to physically remove infringing signage, okay, which has been already installed. So almost every trademark interim application which you will draft in practice are generally prohibitory in nature, like you are asking the court to freeze conduct and not to force a new action. So better to keep that distinction in your mind. Now, this is the slide like I wish if someone had shown me in my first year, okay, because these three words get used interchangeably by students constantly, and they actually mark three completely different stages of the same suit. If we talk about ad-interim, it comes first and it is often granted or very soon after the filing, and sometimes without even hearing the defendant. And it is a short fuse order that lasts only until the IA itself is properly heard. Okay. And the interim comes next, which is granted or refused only after both the parties have argued the IA, and it lasts until the suit is finally decided, which could be years away. Okay. And the permanent comes at last, okay, because it is granted only as a part of the final judgment after a complete trial, and that is the ultimate relief that the suit was often filed to obtain. Okay. So today's application, our IA under Order 39, Rule 1 and 2 is asking for the first two, which is an ad interim order right away and an interim order to follow once the defendant has had a chance to respond. Okay. Now, it like where does our suit is actually get filed? And this depends on Commercial Courts Act 2015, which was amended in 2018, and mm, here it governs that a commercial dispute, including a trademark suit, is filed based on its specific value. Like for below 3 lakh rupees, a dispute does not even qualify as a commercial dispute. Uh, it goes to an ordinary civil court, and between 3 lakh and 2 crore rupees, it goes to the district level commercial court, and 2 crore or above, specifically in Delhi, it goes to the commercial division of the Delhi High Court itself. Okay, so for our matter, Sundrop Beverages claim once you add up damages and redemption of the accounts or the value of the injunction relief, it will exceed around 2 crore rupees. That is why our cause titled CS Commercial, which is filed before the commercial division of the Delhi High Court, not a district court. So this matters practically. Okay, get the specific value wrong and your suit can be returned for the want of jurisdiction before you even get to argue the merits. Uh, Now, let's actually read the provision because far too many students cite Order 39, Rule 1 and 2 without even having read the bare text. Okay. So Rule 1 in summary says that where it is shown that property in a dispute is in danger of being wasted, damaged, or wrongfully sold, or the defendant threatens to dispose the property, uh, or he threatens to cause an injury regarding to that property, then the court may grant a temporary injunction. Okay. So notice one thing here that this rule was originally drafted with a physical property dispute in mind, which could be think of a land or a building or any tangible asset. Rule 2 is what actually extends this to our world. It allows the court to restrain a defendant from committing the breach of contract or other injury of any kind. And it is that phrase, like other injury of any kind, that trademark infringement actually relies on. Our client is not protecting a plot of land, it is protecting the goodwill and distinctiveness of the mark Sunoora. So, which the court have long recognized as exactly this kind of injury. So when you cite Order 39, Rule 1 and 2 in a trademark IA, you are really leaning on Rule 2's broader language, read together with Rule 1's procedural framework. Okay. Now you have seen the heading of every IA you will ever draft, because it would be like uh, under Order 39, Rule 1 and 2 to be read with Section 151 of the CPC. So here question comes that why is the Section 151 is always tagged along? So Section 151 of the CPC preserves what is called the court's inherent power. Okay, means the authority to pass any order necessary for the end of justice or to prevent the abuse of its process that is not already expressly provided for elsewhere in the court. So practically, this does two things for us. First is that it is a safety net if some specific relief we are asking for does not fit neatly within the precise wording of Order 39. Then Section 151 lets the court still grant it in the interest of the justice. Second, that it signals to the court that we are invoking its full discretionary power, not just narrowly relying on one statutory rule. So, this is a small phrase, but I want you to understand why it is there rather than just copying it mechanically into your applications. So, here is the foundational point that most drafting classes skips entirely, and I think it is one of the most practically important things you will learn today, which is about Section 12A of the Commercial Codes Act, which makes the pre-institution mediation mandatory before filing the most commercial suit. Uh, and there is exception that where the suit contains or where the suit contemplates any urgent interim relief. Okay. So the Supreme Court in a case of Patel Automation versus Rakeja Engineers in 2022 confirmed that this mediation requirement, okay, uh, mediation requirement is mandatory and it is not an optional. Okay. So think about this, that what this means for us. Like if the Sundrop Beverages had not been able to show any genuine urgency, then they would had to attempt the mediation with Sunoora Foods first. Okay, and that process could take months, and during this time period, the infringement would simply continue. Okay, but the court don't let plaintiff claims urgent really casually. Okay, the Supreme Court, whereas in uh, clarified in Yamini Manohar versus TKD Kirti, that urgency must be genuinely contemplated by the facts, not to be pleaded as a device to skip the mediation. Okay, this is exactly why the acceleration facts we build into our IA. The notice is ignored, okay, and the sale is continued. So they don't just justify the injunction itself, they justify the client's very right to be in front of judge today instead of in a mediation room for the next 3 months. So let's pause here before we moving into our drafting. If you are a first year student, and this is the slide I want all of you to screenshot, because this is what we have learned today in part A, that an injunction preserves the status quo. It is either prohibitory or mandatory. And then we discussed about ad-interim, interim, and permanent injunction, which marks three different stages of the same suit. Then the specific value determination, like whether a suit will go to a district commercial court or to the High Court's commercial division. Then in Order 39 Rule 2s, we talked about other injury of any kind is what brings trademark infringement within the scope of Rule 2. And then about Section 151 of the Code's residual and inherent power, which is a safety net alongside Order 39. And at last, we have discussed about the Section 12A, in which we see that it allows a plaintiff to skip mediation. Uh, okay, so now we now we move into drafting. Okay, everything from here builds on foundations we just covered and continues directly from our Cease and Desist Notice session, which was on Sundrop Beverages against Sunoora Foods. So, a quick recap of the timeline because it is a single most important asset in today's drafting exercise. Like on 14th July, we have seen that the infringing product was discovered at CP retail outlet. On 31st July, a cease and desist notice was sent and 15 days to comply. On 15th August, a deadline lapses and there was no reply and no compliances. On 20th August, our client returns to the same outlet and finds that the goods are still openly sold and purchased uh, one unit as a evidence. Okay, so that last fact is going to do enormous work for us today. Okay, so this is the single most important slide of part B because this test, the three pillar test, comes from a case of Wonder Limited and another versus Entox India Private Limited, which was given on 26th April 1990. Okay, so it was a passing of dispute over the mark CalDC for calcium gluconate tablets, and critically, it was decided under the very provision of our application is filed under, which is Section 39, sorry, Order 39, Rule 1 and 2. Okay, so in this three pillar test, the pillar 1 is prima facie case. Okay, uh, it is not proof beyond doubt, just a genuine and triable question. And pillar 2 gives the balance of convenience that if I refuse relief, who will suffer more, either the plaintiff or the defendant? And in pillar 3, that is the irreparable injury, that court have to think that can money alone will fix this later. So one thing worth knowing about this case, that the Supreme Court also held an appellate court, that an appellate court cannot casually overturn a trial court's decision on interim injunction. It can only interfere if the trial court acted arbitrarily or ignored the settled principle, and that is a separate point. But it tells you how much weight the trial court's assessment of these three pillars actually carry. So get this right at the IA stage because it is hard to undo later. So here is a practical trap that catches out even the junior advocates, not just the students, because the default position under section Order 39 Rule 3 is that the court must give the opposite party notice of your application before granting an injunction, unless uh, granting that notice would itself defeat the purpose of the injunction, because the delay would let the defendant act before the order takes uh, effect. Okay, so a proviso which was added in 1976 makes this stricter. Like if the court decide to grant relief without notice, it must record its reason in writing, and it is not optional. The court have to vacate, the ex parte injunctions purely because this requirement was not properly satisfied by the applicant. And there is a duty that comes right after, like once you get an ex parte order, you're expected to promptly furnish the defendant with the copies of everything, like the application or the affidavit or the exhibits and the plaint. Okay. Uh, you cannot sit on an ex parte advantage silently. Okay. And finally, Rule 3A. So once an ex parte injunction is granted, the court is supposed to make an endeavor to finally dispose of the application within 30 days. In practice, this timeline often stretches, but it tells you something important, that an ex parte relief is meant to be a stopgap, not a permanent state of affairs. Uh, 10 parts. Notice the first half echoes what we build into the plaint and the cease and desist notice. Part 5, the acceleration fact, is what is specific to an IA following an ignored notice. Part 6, 7, 8 are our three pillars, each pleaded separately, and then the prayer close and the verification. So let's build this against our real case file. Uh, Part 1, the cost title. Okay, so you can see that here we have to write the IA number of the year uh, in commercial suit number this of the year. Okay, now here you have to give the title of the plaintiff or applicant and the respondent and defendant. Then the para 2. Para 2 is basically a drafting habit I want you to adopt, because the first paragraph of almost every IA incorporates the plaint by reference instead of repeating it. And this gets straight into the urgency the judge actually needs to hear about. Uh, Paragraph 5 recites the notice, like the date, the demand, and the deadline. And paragraph 6 is where the real works happen. Like, despite due service, that defendant neither replied nor compiled, and our client found the goodwill still on sale after the deadline and purchasing one as an evidence. So, this single paragraph proves something the plaint alone cannot, that the defendant was given a fair chance to stop voluntarily and he chose not to stop. That is a direct evidence of continuing and a willful infringement, which is dated after a formal notice. So now the drafting skills itself, for each pillar, look at the weak version. It just restates the legal label that plaintiff has a good case, uh, or the plaintiff will be inconvenienced, or the plaintiff will suffer loss. None of these tells the judges anything that they can actually test. Okay, now look at the strong versions, like the each one anchors the legal label to a specific dated and evidence fact, like prior use since 2017, the post notice sale, and the ongoing dilution proven by the same sale. Okay. So this is the pattern I want you to internalize. A legal conclusion without a supporting fact is just an assertion. So a judge cannot act on an assertion, you know. So every single pillar you plead needs at least one fact doing the actual work behind it, right? Okay. So now the two key precedents I want every one of you to citing correctly, not just vaguely referencing. And you know, we have already discovered and talked about this case, the Wonder versus Entox, for the three-factor test itself, and for the important companion principle that an appellate court may only interfere with a discretionary injunction order for a clear error of principle, not merely a different views of the facts. We have already discussed this. And the second is Cadila Healthcare versus the Cadila Pharmaceutical 2001 case. And this was a passing of dispute between two pharmaceutical companies over the mark Falsigo and Falsitab, which both are anti-malarial drugs. And in this case, the Supreme Court laid down seven factors for assessing deceptive similarity. The seven factors are the nature of the mark, the degree of resemblance, the nature of the good, the similarity in character, and the class and care of purchasers, the mode of purchase, and any other relevant circumstances. Okay, so when you draft your prima facie case paragraph in trademark IA, you are essentially running your facts through this seven vector Cadilla test. So you need to cite it properly and cite it by its actual paragraph finding, not just by the name. Now, two practical checklists. So before you file anything, make sure that you actually have the registration certificate and the cease and desist notice with the proof of service and your evidence of continued infringement along with affidavit in support and your wakalatnama and court fees. So if you miss any of these, these can get your application returned or delayed. And after you file, the court may grant ad interim relief according to the reasons. If it's an ex parte, so you are then required to promptly serve the defendant with notice and the copies, because the court is supposed to make an endeavor to dispose of the application within 30 days under Rule 3A. And the defendant, once served, can apply to vacate or modify the order under Rule 4. And eventually, once both the sides are heard, the interim order either gets confirmed as interim order, or it could be modified or vacated entirely. So I want you to internalize this, that getting the ex parte order is not the end of the story. It is the opening move. Okay. Now, just like the operative demand, was the most important sentence in the cease and desist notice. In the previous video, we have learned about this. So here in IA, the urgency prayer is the most important sentence. And a generic ask tells the judge nothing about like why I can't wait. So our prayer tells the judge exactly why the relief needs to be urgent, and that points to a specific dated and provable facts to justify this. Okay, so you need to like explain the prayer in a proper manner, that why your application is urgent, why you need urgent relief. So there should be specific dated and provable facts. So before we move further, I want you to see that everything what we have built today is not a classroom fiction. You know, the Indian courts grant exactly this kind of relief regularly in various matters that are look a lot like ours. Okay, for example, in Bata versus Mittal Footcare, the Delhi District Court grant an ad interim injunction restraining the footwear sold under marks and lettering uh, which are deceptively similar to the Bata. Okay. In another case of Albeck versus Arsalam, the Delhi court granted an ex parte injunction against unauthorized franchising under the mark Albeck for restaurant services. Similarly, in matter involving a cafe called Social Chai, the Delhi High Court granted ex parte ad-interim relief, and court hold that simply adding a generic word uh, to an existing registered mark was not enough to avoid the deceptive similarity, and which, if you think about it, is almost exactly similar to our case and Sunoora versus Sunoora fact pattern. Like the word uh, O is just added as a letter instead of the suffix. So this is the world our application is actually operating in. Okay. Now, we have covered the theory, the three pillar test, the precedents, and everything. Now, I want you to stop talking about drafting in the abstract and show you the exact uh, complete application built from everything, whatever we have discussed till now. And I will go through this by paragraph and the same way as we went through in cease and desist notice in our last session, because I want you to able to point out to any single line in this document and tell me exactly why it is there. So for that, the facts of Sundrop Beverages versus Sunoora Food case we have already discussed in the previous video. These are the parties and the defendant and the plaintiff, and the trademark which was registered having the following details, having the registration number in class 32, and it was registered since that date, and it was continuously used since March 2017, and the trade dress of the trademark Sonora. Additional information, whatever we are taking in this example would be this, that we would be disclosing the revenue and the sale volume along with the infringements detail, like what was the infringer's mark, the impugned mark. So before paragraph 1 even begins, so you look at the top of the document in the High Court of Delhi thing. You know, I want you to notice the word in. The IA number is not independent, it lives inside the suit. And then comes to the party that you are explaining here as Sundrop Beverages Private Limited versus the Sunoora Foods as defendant. And then the heading of the application itself, the application under Order 39, Rule 1 and 2, read with Section 151 of the CPC. So everything, whatever written here about this word "so with," or in this drafting style, respectfully submits as follow, is not just a filter. Uh, it's a jurisdictional identification, because uh, a judge, a court clerk, or an opposing counsel should be able to read only this block and exactly know which case, which court, and which specific relief is being asked. Okay. Now, come to the this paragraph 1, that the plaintiff has filed the accompanying suit for permanent injunction restraining the infringement of trademarks, passing off unfair competition, damage, and redemption of the amounts accounts of profit and delivering up uh, against the defendant. The plaint may be referred to. So one sentence here, and this does an enormous amount of work, because notice one thing here, that what we does not do. We are not repeating the entire actual facts of the background. We are not repeating the entire factual background of the suit. We simply says that the plaint exists, and Here is what it seeks. So go read it if you need the full picture. Why does this matter? Because the judges in the commercial division are managing thousands of matters, and if every IA repeated the entire plaint word for word, you would be wasting the one thing you actually need from the judge in this hearing, and that is their attention on the urgency. So this paragraph is a courtesy to the court, but it is also a strategic drafting, and it clears the runway for everything that follows to be about why relief is needed right now, not retelling the whole case. Okay. Now coming to the paragraph 2, that by the present suit, the plaintiff complain against the defendant for dishonest adoption and use of impugned mark Sunoora, which is deceptively similar to the plaintiff's prior used registered trademark Sunoora in respect of the identical goods, namely packed fruit juices in uh, class 32. So this is your entire case compressed into a single sentence, and I want you to notice four things which are happening simultaneously in this one line. The word dishonest, the, this word is not decorative. It signals the malified intent of the defendant, and this matter a lot for balance of convenience. Now, the word deceptive similar, that is exactly the legal standard under Section 29 of the Trademark Act shows. And the word prior used, registered, this is your prima facie case in four words. And you were the first, you were registered, and you have identical goods, namely in fruit juices in class 32. So all these things closes off any argument that is a different market or different classes of goods would be there. So if a judge only read this sentence and nothing else, they would already understand the entire course of action. And that is the test for whether paragraph 2 is doing its job or not. Okay. Coming to paragraph 3, this paragraph exists to prove one specific thing, that the plaintiff has real and prior right, not just a registration setting unused in a drawer or somewhere else. Okay, so notice two dates, that it was registered in March 2018 but used since March 2017, and this gap matters here because it tells the court that this mark has been alive in the market for years. And then the number we are disclosing here as 12 lakh units, 42 crore rupees in a single year. So why we include sale in an interim application at all? You know, because uh, goodwill is not just a word you assert. It's something you prove with evidence a judge can actually weigh. And a court is far more likely to protect a mark that is clearly generating real commercial value than the one that exists only on the certificate. So this is your prima facie case. You made concrete with numbers instead of the adjectives. Now, paragraph 4 is where you exactly run the Kadila healthcare seven factor test as we discussed. So you are not just labeling it that way in the document itself, and a single additional vowel you read here. This is your resemblance factor, and identical goods, class 32 from paragraph 2. This is your nature of goods factor. And here notice something that students often forget to plead. It's not just the word mark, the orange and white packaging the citrus divides. That is your trade dress, a separate and additional ground for confusion. stacked on the top of the word mark similarly, right? So the phrase, if you read here, manifestly intended to misappropriate, is doing quite but an important work too. So you are not just saying the mark look alike, you're saying that the defendant meant for them to look alike. That is a deliberate action. And that is the difference between the innocent coincidence and dishonest adoption. And it is the kind of language, a judge remembers when weighing the balance of convenience later. So make sure that you apply the seven factor test, which we discussed. Now, paragraph 5. Uh, I want you to slow down with me here because the single paragraph is doing more strategic work than any other part of the application, and I want you to see exactly how. So first, we will divide this complete one paragraph into various sub-paragraphs, and then we will discuss about each one. So for the first, you read it here as, the plaintiff discovered the infringement on 14th 7/26 when its representative found the impugned good being sold at retail outlet in Connaught Place, New Delhi. Photographs whereof are annexed. Okay, so here we are talking about the discovery, a specific date and a specific location, and it says photographs were of are annexed. So remember one thing, that you never allege a discovery without saying when, where, and what evidence backs it up. Okay, coming to next. Upon discovery, the plaintiff through its counsel addressed a cease and desist notice on dated 31st 7/26 to the defendant, calling upon it to inter alia cease and desist from the use of the impugned mark within 15 days. So here you notice one thing, that the notice, the date sent, and when it demanded, or what was the demand, and the exact deadline, that the 15 days were which were expiring on 15th of August. So this is not just narrating a history. It is establishing that the plaintiff gave the defendant a fair and documented chance to stop voluntarily. Next, and in the next sentence, it says that despite uh, due service of the said notice, the defendant neither replied thereto nor complied with any of the demands made therein, the cease and desist notice. So, this is the sentence I want you to remember for rest of your drafting career, that, you know, even you have served the notice, the defendant neither replied to that notice nor complied with any of the demand you made therein. So, after in proper notice is being served, silence itself becomes an evidence, and it's, this silence tells the court that it is not defendant who might have a genuine misunderstanding. It is a defendant who was told clearly, but the defendant choose to continue anyway. Fourth, we talk about a follow-up visit on 20th August after the deadline of 15th August was lapsed. You find the goods still on the sale, and even you actually purchased one unit with a cash memo as evidence. This transform the defendant is infringing into a thing that the defendant is infringing right now, which is a proof that after being warned, the defendant continue infringing the mark. So this distinction is a difference between an applicant that waits week for a hearing and the one that gets a judge's urgent attention that the defendant is still infringing the impugned mark. Now, coming to the fifth part, that the price undercutting and the identical trade channel. So, this is not just, about the confusion anymore. It is about the active market harm which is happening in real time. And finally, the defendant has not filed any application for the registration of the impugned mark in India, and no prior relationship, license, or authorization exists between the plaintiff and defendant. So, this particular paragraph closes off any preemptively the defense which could be raised by the defendant in court that we have our own pending registration or something like that. We had some arrangements with the plaintiff. Now, with this sentence, both the doors are shut before the defendant even gets a chance to open them. So, this is what I mean when I say a single paragraph can serve multiple purposes at once. This paragraph 5, alone builds your urgency case. Now, coming to paragraph 6, you notice the specific harm being argued here. And it is not just that we are losing sales, it is the quality control argument that if the defendant's fruit juice is poorly made and it was contaminated or simply a bad, so consumers who mistake it for our plaintiff will blame the plaintiff brand for something the plaintiff never even made or can't even control. So this is a classic irreparable injury argument because you cannot put a rupee value on reputational harm from a product you have never manufactured. And then the paragraph ends up by asking the injunction by the way of an ex parte ad interim injunction. So here this is a deliberate placement because you have spent 5 paragraphs building your factual foundation, and only now, once the reader is already convinced, so do you make the explicit ask? Because you never led with a demand before you have earned it with facts. Coming to paragraph 7, here is something I want you to notice because it is genuine stylistic choice, not a shortcut. Because we have discussed the prima facie case, balance of convenience, and the irreparable injury as 3 separately labeled paragraph. But here, all these are pleaded in a single paragraph. Okay. And in the prayer clause, now I want to explain something about the prayer in general before we look at our specifically each of the prayers. Because I don't think students are ever properly taught why the section even exists. So every single fact which you have pleaded in paragraph above, the registration, the discovery, or the ignored notice, all of it exists for one purpose only, that is to justify the specific things you are about to ask the court to do. So the prayer is not a summary, it is an actual operative request. Like if a judge granted you exactly what your prayer says from word to word and nothing more, then would your client be protected? If the answer is no, then the prayer is incomplete, no matter how good your factual paragraphs were. So coming to paragraph 1, we says that grant an ad interim injunction restraining the defendant, its proprietor, and any other partner, employee, agents, or any other uh, acting for an end on its behalf from what purpose? From manufacturing, selling, offering for sale, advertising, promoting, distributing, exporting, and any other good under the impugned mark or any other deceptively similar mark. So I want you to notice how long the sentence is, and I want you to understand that the length is not accidental or a lazy drafting. It is a deliberate legal precision. Why? Because look at the list of people bound, not just the defendant, but all its proprietors, the partners, the employees, the agents, the distributors, and all other acting for or on its behalf. So, why we need this? Because if your injunction only names the defendant company, then a clever defendant can simply route the same infringing goods through its distributor or a stockist and argue technically that they were not named in the order. So this long list closes every one of those loopholes in advance. Okay. The same logic applies to the list of verbs of manufacturing, selling, offering for sale, advertising, and importing, exhibiting. So here, every single mode by which infringing goods could move through the market is named. If you only wrote about the restraint from selling, or then a defendant could keep manufacturing and stockpiling the good, or keep advertising the impugned mark, and they would argue that they complied with the order because they were not technically selling or anything yet. So this is really important to understand that you name each and every part of the defendant's company and their work. Now, the prayer clause too. So this is the sentence what actually invokes the urgency we built our entire acceleration facts paragraph to justify. It is short, but it's carrying the weight of everything in paragraph 5. So this is also structurally where your section 12A arguments live. Remember, this is what allows the plaintiff to be in front of judge today instead of in mediation. Okay. The subparagraph 3, and this is the residual pair, and I want every one of you to include some version of this in every application you ever draft, because courts have wider discretion and you cannot always predict every specific order they might think is appropriate. So this clause simply ensure that you have not accidentally boxed the judge into only the exact word which you have wrought, and it preserves their full discretion to grant relief you may not have specifically anticipated. And finally, the plaintiff or applicant can through the counsel with the place and date. This is the formal and formal closing, and in complete filing, this would typically be accompanied by a separate affidavit verifying the facts, which we discussed earlier when we covered before you file checklist thing. So some practitioners include a verification paragraph directly in IA itself, and other in this drafting style keep it in a separate affidavit. Either is acceptable, but one of the two must exist there, because an unverified application carries no evidentiary weight. So five mistakes I see most often: that you repeat the plaint instead of incorporating it by reference. Another one is that you plead all the three pillars as one vague paragraph, or you ask for urgency without a specific reason that why it is urgent. Or in the end, if you forget to refer, then exerts, or you miss the verification clause, then these mistakes can weaken your IA. Now let's recap the whole session from both the parts that we have studied in part A, that the basic part about what an injunction actually is. And we also studied about that every paragraph in IA must serve one of the three pillars from Wonder versus Entox. Or we also studied about the genuine urgency uh, is not just a persuasive language under Section 12A. It is a legal gateway that the plaintiff skips mandatory mediation entirely. And then we have studied about this thing that a strong paragraph of fact uh, can or should be reused across multiple paragraphs. And we also studied in that you draft the prayer clause like the judge will read it first, because very often, the judges do read it. Now it's your turn. Uh, you continue the Miraki matter. Pause here, take your time, draft the exhalation fact paragraph, the irreparable injury paragraph, or the prayer, the urgency prayer. So you test your urgency prayer against one question, that does it points to a specific or dated fact, or does it just assert urgency? Okay. Now, this brings us to the end of today's session. We started from the first principle, that what an injunction is, and we ended with a fully built fact anchored interim application, which is backed by real statutory provisions and real Supreme Court precedent. So, before our next session, you practice today's structure on Meraki fact pattern in full. In the next class, we move to drafting the plaint itself. And as always, please follow Patenevo on Instagram or LinkedIn at patenevo.in. Thank you so much. Have a great day.